Hello, good night. This is U.S. Immigration Attorney Sharifa Tharp. I'm here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments now. Tonight, I want to talk about getting relief that could also get you protection from removal, from deportation. So I want to talk about how that works, the dynamic of that, and the benefits of it, of applying for relief, what we've been seeing on the ground as we apply for relief and also as we tackle removal. So we are also helping people who are in removal proceedings. We are defending people. And so we're able to see from multiple perspectives what it looks like. And what I have noticed is that those individuals, so our clients who have relief, so they were our clients previously, they were applying for relief, and then maybe they got a notice to appear, or they were detained. That because they have this pending relief, we're able to find. First of all, it helps with their immigration case, so it helps their immigration case in court, in that it is a serious consideration. Once they do see that an individual qualifies for relief or they have a pending process, it does help with their defense. Where we have been having challenges is where there is nothing, right? So if we get a call out of the blue and this person is detained, we get a call out of the blue because they're detained, and it's the first time ever that they are trying to seek relief, right? They're in detention, they're trying to come out. What we have noticed is in those cases, because that person did not try to seek, I don't know the extent to which they tried to find relief in the past, but because first of all they're detained, it's hard to get in touch with them. Once they're detained, they become an A number in the system. And it doesn't mean that we don't get through. Eventually we do, but precious time is lost because we have to spend a lot of time locating our client, getting in touch with them, establishing that we're representing them. That alone does take about that first week just to establish that we are representing the person. Then we have to talk to family members, right? Because we can't talk to the client who is detained. So we have to get information from family members, which can be challenging. Because when we are trying to review all the forms of relief that we can then bring to either ICE or bring to the court and say, our client qualifies for these reliefs or they have this pending relief, then that makes it easier because then their case gets continued. They may be able to get bond based on that. But when we're talking to family members for the very first time, and those family members maybe don't even know as much as their detained family member, we can't get crucial information that could help in their defense until another week, until we talk to the client. And furthermore, if there is an existing deportation order, that becomes an urgent case, right? That's an urgent case where you absolutely need to have a stay of removal right away, because if you already have a removal order, what they're doing is they're working to get people out ASAP, put them on a plane and send them out because they already have a removal order. So, having pending relief, making sure that you're evaluating your options is crucial, and it helps. It helps, and it does make a difference in our ability to effectively defend somebody who we know from the get-go. We know their history, we know what they qualify for, we know what they have pending, and that helps us to get a head start. right? We already represent them versus someone who is calling out of the blue. We can definitely represent that person, but our job gets a lot harder because now they're detained and it gets sketchy. It does get sketchy when people are detained, right? Most of the time, we're working with the family members at first, trying to get crucial information in order to get the representation established. So this is where I say get, if not our law office, you're calling an attorney, you're getting your options evaluated to see if there is relief out there. I know a lot of people, a lot of people believe that, okay, if I don't get the relief right now, it's not worth it. But having pending relief means you're on the way to it. It means that you do have the ability to use it as a potential defense, or to use it as to show that you do deserve bond if you are in a situation like that, right? So think about that, guys, because I'm telling you that from the front lines. I'm telling you that because I can clearly identify the challenges and the differences that we have noticed when we have our clients that have existing or pending relief, because we have screened them for it. We've talked to them beforehand. Most of those clients that have we've successfully defended, we knew them from before, and so we're able to quickly jump on their defense in regards to removal. Now, if we're starting from the start with someone and we don't know them and they've never had any, they don't know their options, their family members don't know their options, that's where it gets difficult. So to make sure that you put yourself in the best position possible, make sure you are watching out for yourself. I'm going to tell you 5 things that you can do right now to make sure that you give yourself a strategic head start. So, one is build a relationship with an attorney, establish one. Our clients that have been detained, that we have advocated to be released either before ICE or through the bond hearing, we had a G28 already signed. So that meant, what that means, a G28 is a special form. Immigration, they will not talk to you without that G28. But as we can quickly establish, we represent this client by showing the G28. So communication can open up much easier. We can gain access to our clients much faster because we already have a G28 on file. So make sure you're establishing a relationship with an attorney, that an attorney understands your case. An attorney can evaluate your case beforehand, can tell you what to expect, what relief you have that could keep you out of a situation like that to begin with. And if anything like that happens, what next? How do you move forward? The other thing is, especially if you have a removal order. Now, the scary thing is some people have removal orders and they don't even know they have it, right? So there is a way that you could quickly check. You could go to the EOIR case status page. So you'd probably have to Google it. It's on the official, I believe, I think it's Department of Justice website. But do EOIR case status. If you know your A number, put your A number in. And if you do have a case history that you don't know about, you will see it there. You will know by that A number. So you can always use your A number. What I've seen is people who have, for example, they were going from a 2-year to a 10-year, and somehow they did not apply for their somehow they never went through with the removal of conditions. Those individuals I do remember that I've found 2 cases where they did have removal orders that they had no idea about. So you can always check there to see if you can apply, if you have a past removal order. The reason why that's important to know is detention becomes urgent, right? At detaining someone with a removal order means that they can put you on a plane pretty quickly and send you out. And that means that your attorney has to be sure to urgently file a stay of removal, right? And it's called the I-246 form, and it's the stay of removal. And that can submitting that can put a temporary hold on your case while it's being reviewed by the immigration court. So that is going to have to be a start. So knowing whether you have a removal order already, and then fixing that, right? So if you find out that you have a removal order, there are ways to fix it, because obviously if you didn't know that you have a removal order, it probably means that it didn't get to your address, you didn't get proper notice, and because of that you can get your case reopened and you can still move forward with your defenses, because as long as you can show you changed addresses, or it went to the wrong address, or some issue happened that caused you not to get notice, you can get your case reopened. So I would say be proactive in that situation. Don't just sit down and hide and say, okay, I I have a removal order. That means I need to definitely sink deeper into hiding. At that point, you need to tackle that and tackle it upfront by getting your case, putting in a motion to reopen based on this evidence that you did not have proper notice, and because of that you need to have a chance to put forth your defenses. Now, being detained and going into immigration court is very stressful. It's stressful for the family, it's stressful for the individual, especially when you have been here for a while, you've built a family here, it's stressful. However, I want you to know, because what I go off of is I go off of faith and hope and action towards those, right? So we're solution oriented. And the way I look at it here is when you are called to the court, it means that you do have the ability to put forth your defenses there. So even if, for example, I'll give you an example, there is what's called cancellation of removal. Like people always say to me, is it true that if you're here for 10 years, you can get your green card? Now, the reason that question comes up is because I'm pretty sure somebody heard that somebody ended up in court, and then they came, instead of being deported, they came out with a 10-year green card, right? So now people think, oh, I can just be here for 10 years and get the green card, but that's not exactly how it works. But what happens is when you do go to immigration court, if you've been here for 10 years, you have good moral character, you have relatives here, US citizen, certain US citizen, or permanent resident relatives, usually immediate relatives, so the wife, spouses, children, and parents here, who will experience extreme hardship if you leave, then you are able to get your cancellation of removal and get the 10 years. Instead of being deported, you get a 10-year. So getting sometimes it gets a little harder before it gets better. So even if you're facing removal, you can still seek options and relief. So don't I know it's stressful, but don't give up on yourself. And this is no matter where you are in the process, don't give up on yourself. Be proactive, because that is how you're going to fix things. And that is how my clients are winning. They are being proactive. And that's why they are in a better position now, right? It takes risk. I just saw, I saw a video of my client talking about what we did for her. And I remember clearly, she's my dear client, and I remember clearly the state that she and her family were in when they came to me. They were scared. They were especially scared of being detained and deported because they didn't have their papers. But because I was able to lay out to them the relief that they qualified for, they were scared. They took the chance. And now the entire family has their 10-year green cards here because they took the leap, right? But they took an informed leap. They took an informed leap, right? They came to me, they told me what was happening. They thought there were no options, and I provided them the options that have now made them succeed. It's the best feeling, right? But at first, it's scary for everybody involved, but you have to take the action. And the thing about it, guys, is the first action that you should be taking, which is going to an attorney, is, I would say, the easiest option, right? And why I say it's easier is because it's a safe space. Your attorney, our law office, is a safe space. So you're not coming there. You're not coming into my office to get into trouble. You're coming into my office to be informed about your options and to fully walk away empowered, right? To have that knowledge, to know what to expect. How are you going to move forward? Come up with a plan. So if something happens, how are we going to move forward, right? Or how are you going to move forward? That's the easy part, right? So it's still at that point, it's still not an unsafe situation. We are confidential. We keep everything confidential, and by law, under the rules of professional responsibility, we have to keep your information confidential. When you become our client, we keep it privileged, right? It's the most sacred aspect of the attorney client relationship. So just know your options, because having options, having a pending process can actually, now having a pending process for us means that we truly believe that based on our experience, based on our competence, that you qualify, you have a good shot at getting the relief. So that's the good news. The other thing though is that once we know you have that option, you have a head start, right? And that's because with that knowledge, if anything happens, we can advocate with that knowledge that we have about you, that you qualify for something, that you have a pending process going forward, that you are on your way to getting protection here. So you can give us a call. We're 24 hours a day. Give us a call no matter what situation you're going through in immigration. We want to hear from you. We want to be able to determine whether we're able to help you. So start there. I would say that's the easy part. All right, so let me go ahead and I'm going to answer some questions. Hello, good night. Hi there, Althea. Good night. Um, I have I-360 pending for almost 2 years, want to change attorneys. So your reason for changing the attorney, it's always your right to change attorneys. In regards to that, sometimes, if you are already represented, you've already filed your documents with an attorney, it depends on your situation. But at that point, with our law office, once your case is filed, there may not be much we would be able to do to fix your case if another attorney already filed your case, and it may just be a waiting, right? So you said you have it's pending for 2 years. Hiring another attorney isn't going to change the processing times. So a lot of people think that it's taking long because of the attorney. and that's not true either. So having your case pending, hiring another lawyer isn't going to fix that. But if there is a situation that needs correcting, you need to get a second opinion. But it's always your choice to definitely make sure you're looking out for yourself. And if you're not satisfied with your attorney, then seek another attorney. Um, all right. So now I'm on YouTube, Facebook, and then I'm going to go to TikTok. Hello on TikTok. Okay, U visa is still processing. I heard some other lawyers said it's no more. No, that's not true. We are still seeing bona fide determinations and work permits coming. So it's still coming in. So don't. A lot the people are saying a lot of things. We are getting work permits, T visa work permits. Um, Family-based work permits, asylum work permits. We've gotten asylum approved. It's still moving forward. So that's not true. The U visa is still there. But the U visa, what happens? The U visa takes about 10 years total. But what you do get is in the meantime, you get your bona fide determination and your work permit, 4-year work permit that's renewable. Can someone else still file a T visa application even if the incident happened in 2019? Thank God. God bless you. Thank you so much. Thank you for that. Um, Absolutely. Absolutely. Guys, I got the T visa for a client who was victimized 30 years ago. 30 years ago. She came in the 90s, and we got her the T visa in 2022. So no matter how long ago this happened to you, no, and if you're just joining me, you're probably wondering what the T visa is. If you don't follow me, I'm going to tell you what the T visa is very quickly. T visa is for certain victims of trafficking. Now, keep in mind, trafficking, you when you're here in this live, you're going to be educated, just like I had to educate myself about what that is, because I wanted to help people. And what I was getting was a lot of people coming to me and telling me these horrible situations that they're in, right? But they didn't exactly fit that mold of what I thought was trafficking, right? So they would tell me things like, I'm working for somebody, they're not paying me, they have me sleeping in the shop, and staying in the shop. They can't leave the shop because they close the shop and leave them in the shop. They sleep in the shop, they wake up, they have to work all day and then stay in the shop, right? And they don't get paid for the work they're doing. And something like that, it's wrong. But when initially, when I thought about trafficking, I thought about trafficking in terms of, sex trafficking. Somebody kidnaps somebody out of a parking lot and then holds them, chains them up somewhere, sells them across the border. That's what I pictured. Educating myself in order to help people like this person that was in the shop, not getting paid, enabled me to expand my horizons. I quickly learned that immigration provides relief for individuals who are in the situation, because what was happening, that person that was in the shop not being paid, being locked in the shop, was a victim of labor trafficking, right? So when you look at this person from day to day, they look like they're going about their day normally, right? You don't see them locked up, you don't see them chained up anywhere. They you know they look like they are free. They're making willful decisions. But what's happening is this shop owner was doing things like, they weren't free to leave, because how are they going to leave when they're not being paid enough to leave, right? And then they can't find a job because they're not being paid, and they have to keep working just in hope of getting the next paycheck. So they keep them in this cycle. And then they're undocumented, right? So the next thing is like, well, what are you going to do? You're undocumented. You don't have your papers. So we can call ICE on you if you don't do what we say. And you're going to stay here in the shop. That's just the way it is. I'm going to lock up the shop at night and you're going to stay in the shop, right? So it's a form of coercion that's happening. So it's like, it's not physical force, but it's a type of coercion, and that makes it trafficking. Because nobody who has free will is going to live under conditions like that. So if you're experiencing a situation where somebody's holding your status over your head and forcing you to be in a situation you don't want to be in, forcing you to do things you don't want to do, that, my friends, is trafficking. Okay, so that's where you start, and you give us a call, talk to us about what you're going through, and then we can confirm that and move forward with a T visa. So the T visa, and this could have happened if you're sitting down listening to me right now and you remember this horrible, horrible ordeal that you went through 20 years ago that is similar to what I'm describing. It's time to give us a call because there's no time limit. All right. So let's see. Let's go. Mother is a U.S. citizen and child turned 21 after I-130, but before submitting Form I-485. Would it apply receipt notice for I-485? So if the child turned 21 after the I-130 was filed, then they have aged out. They have to apply for the petition. A U.S. citizen has to apply for the child before they turn 21. Otherwise, they go into the 5 to 7 year processing timeline category, right? They go into the category where it takes 5 to 7 years. Under 21, it takes about depending on where they are. If they're in the US, they can file an adjustment of status. But here it says mother is US citizen, child turned 21 after I-130. At that point, it's too late. So do not wait until your child turns 21. They will then get into trouble. Make sure that it is filed before they turn 21. Hello. Okay, so I answered that. Let's see. So can you explain the CSPA? Does USCIS apply it or you need to request it? US citizen for child who turned 21 before submitting I-485 on, okay. So here's the deal. So the CSPA is a Child Status Protection Act, and it was put in place to help make sure that they can still provide the green card or the benefit to children even after they turned 21 in some cases. And there are different formulas based on who the petitioner is. But in this case, if the US citizen parent submits an I-130 for their child who's under 21 before they turn 21, that freezes their age at 21. So that means that if the process takes 5 years, as long as they file the I-130 before they turn 21, then the CSPA protects them because it freezes their age. However, that changes though, depending on if it's a permanent resident who filed for them or the derivatives on the application. There are going to be formulas that have to be applied to determine whether they're protected under the CSPA. Now, under the changes, they have made changes to that. And one of the changes is they were looking at the filing date. So date for filing on the national, it's a little complicated, and a little technical, but they were looking at the date for filing in order for purposes of determining, whether the person could file an adjustment of status application. Now they're looking at final action date. So that's one of the changes. And because of that, though, it is, it's going to disadvantage the children. So anybody who's under 21 who have already aged out, it's going to disadvantage them. So it's a little technical, but that the CSPA just varies. The result of it is going to vary depending on who is applying for the child, and how old is the child. But in this case that you explained, I-130 filed before they turn 21, then their age is frozen. So they can actually, if they're in the US, they should have submitted that I-485 along with the I-130. And filing the petition alone can be a little risky now. So make sure you definitely make sure you do not, you understand the procedural requirements so you don't put yourself in unnecessary risk, because doing something in the incorrect order now can put you at risk for getting a notice to appear. And once you get a notice to appear, guys, your case is no longer going to be under USCIS. They're going to send it to court, and now you're going to defend against removal, right? And now you're facing being detained. So just keep that in mind. Makis, thank you so much. You're very welcome. I appreciate that. Kay, thank you. Thank you for that. And it's my pleasure. I would be nowhere else. This is what my mission is. How long for a T visa to be approved? So right now, processing times is about 22 months, a little under 2 years. All right, let's see what's going on Instagram again. I'm just gonna go through and see. I'm on F1 visa doing bachelor's in ITM. Can I open a business in Illinois like a cell phone repair store? So you can always change your status from the F1 to, and it depends on which country you're from, but there is what's called the E2 treaty investor visa. And that might be one that you could look at establishing, but your country would have to be an E2 treaty investor country. So you can give us a call. Let's talk about it, and we'll look to see what, whether your country, what it falls under, and be able to advise you there. I submitted my VAWA application since May. I haven't received a receipt notice. Yeah, it's taking 3 to 4 months now. I am on F1 status doing my second master's in USA, and my visa is expiring 2028. Can I do PhD after master's after this new immigration law? So they are now talking about making the maximum number of years that a student can be here 4 years. So that hasn't changed yet, but they're talking about that now, limiting students' time here to 4 years. So it all depends whether you're able to. I mean, right now, you are free to keep applying for programs that you qualify for and for the student visa as you enter new programs, but it's going to depend on are there any new laws? Right now, no, but that's the latest thing is they are talking about limiting student visa times. If I have a B1, B2 non-immigrant visa and my spouse who is in the US files my spousal sponsorship for green card I-130, would that be a red flag if I enter the US? Yeah, it could be. It could be, definitely. They're going to ask questions. And if they get answers from you that they don't like, then it could turn into a bigger deal. So I've seen people turned around because they thought they were coming to stay, and so that's where it backfired. Any new rules came for H-1B visa holders for traveling. So they are talking about changing H-1B visa rules. So it would be based on wages. So they're saying that they would give instead of the lottery, they would give preference to H-1B applicants whose companies offer them higher wages. And traveling, not traveling, just be very careful. Make sure if you're concerned about something, you make sure that you are understanding the risk. But in regards to H-1B, that's what they're talking about right now. It hasn't been announced as an official change, but looks like that may be coming down the pipeline. So we'll have to see how that goes. Are you experiencing doing J1 waiver with a 2-year ban? Yes, you can give us a call. We can definitely do that for you. So give us a call and let's talk. Now, usually with the waiver, what we do is we look to see if you are applying for the waiver, because the waiver does not give you status, right? So it's important to know that the applying for a J1 waiver is not going to make it okay for you to be here, but it will allow you to change your status here, because some J1 visa holders are sometimes subject to the 2-year foreign residency requirement. So for example, if you married a US citizen and you have that 2-year ban, well, the 2-year foreign residency requirement, meaning you have to, once your J1 is up, you have to go outside of the US for 2 years, and then you can have the freedom to reapply for another type of status. What happens is when we apply for the waiver, it just means that you would be able to move forward with your adjustment of status. But if you didn't have any qualifications to get any status after that, keep in mind that getting the waiver, yes, it opens the door for options in the future, but it's not going to then just make things okay for you. So just keep that in mind. All right, so let's go to TikTok. What do you mean by someone can change F1 status? So if you're an F1, so meaning a student here, and you would like to change over to an investment visa, or you want to change over to an employment-based green card process, then that could be a possibility. Or you want to change to another visa type. You change over to another visa type. You could possibly do it in the US, but very important for you to understand the pros, the cons, the risk associated with that. I've been waiting 9 months now for my T visa work permit after I received the letter. Yes, so those are still taking a while, and it's just a waiting game right now. The great thing is you have a bona fide determination letter that definitely puts you at a big advantage, because it means that while you're here, they will not be proceeding with removal against you, because they have given you this letter telling you you're protected. So that is a huge step, and it does provide some reassurance while you wait for the work permit. Thanks for the gifts. I appreciate it. The love. Thank you. Make sure you're sharing the live so other people can see this and ask their questions and get information that empowers them. Make sure you like, share, subscribe, follow, do all of that to make sure that you can see me, first of all, when we come on, because I come on every day, Mondays through Fridays, but at different times. So make sure you do that so you can chat me and come on and ask questions, or just to listen to updates, and then also to help others. How is traveling situation for international students now? Well, keep in mind that when you have the F1 visa, it is there. You are able to be moving back and forth. That's what the visa is there for. Just make sure you are complying, right? I know some universities are saying, some universities have been saying don't travel because of the volatile situation. If you feel like it's risky, then protect yourself and just make sure you're not taking unnecessary risk. But technically, the F1 is there to allow you to move back and forth. You're not supposed to just stay. You don't have to necessarily stay here. But if you feel like there is something you're concerned about, it's time to definitely, you know, make sure you're understanding the risk and take action accordingly. How long does I-130 resident mom and I-21 from El Salvador? Um, so if you are 21 or over, expect a 5 to 7 year process. How long does defensive asylum take to conclude? It could be years. So if you're in detention, it could be a matter of months. Being detained moves things along very quickly. But if you are not detained, then they usually set those out longer, so maybe 2, 3 years. If my case is approved, how long does it take as of current to receive the green card? I would say within a week to 4 weeks. Conditions as soon as the divorce finalized. So I have a 2 year green card currently going through a divorce and my spouse is incarcerated. Can I remove my conditions as soon as the divorce is finalized? So here, this is where it's very important to understand procedural steps. So with our clients, once a divorce is pending, we go ahead and we submit the removal, the application to remove conditions. And then at that point, we wait for the divorce to be finalized and we update it. But you do have to show that you're applying on your own, but you don't want the deadline to pass, because if the deadline passes, you can get a notice to appear in immigration court, or USCIS can reject your application. If you have asylum hearing and you have a green card holder girlfriend and you got married, and I didn't see the rest. Now, getting married, if you have an asylum hearing, that's telling me you have court, you get married. Having a green card holder spouse is not necessarily going to help you. It just depends. We'd have to talk very it depends on a lot of facts here and would have to get more strategic. So this is where you need to make sure you get legal advice. You can always give us a call and we can talk you through it. How long does it take for VAWA to get approved? So the total time is about 3.5 years. And keep in mind, along the way, you do get your work permit, you get your travel document, get your social security number. And those right now, they're issuing 5 year work permits. That enables people to live and work here while they're waiting for their process. And that provides a lot of reassurance, protection, and peace. When you're applying for VAWA, it's usually a situation where you can't apply with your spouse or your relative who is not willing to petition for you, or they were and you had to switch to VAWA. And in those cases, just having access to the work permit, the travel document, your social, means that you get independence and reassurance as you're going through the process, and it's within your control because it's your process. You're not depending on somebody that you never trusted to get your papers. How long does work permit take to be issued for asylum seekers? So 6 months, 6 months after filing. And they're very specific on the procedures. So you have to understand that to make sure you don't fall into any situations where you stop the clock, for example, because then you're getting the work permit can take longer. So you have to understand the steps. Is it safe to apply for I-10 now as a visa overstay? So it's going to depend on a lot of facts here. Getting an I-10, what they're doing, IRS is sharing information, but as far as I know, they're sharing information for people who have been have a final removal order. Now, if you're here and you're working, I would say filing taxes is it can help you put you at an advantage. And to file taxes, you need your ITIN. You can definitely we work with clients to get the ITIN. You can call us, talk to us about your goals here, and then we can talk about the pros and the cons and your risk factors. But what I would say here, if you have to choose between, and it really depends on your risk factors here. But one thing is clear, filing your taxes here while you're working is a part of the law. Ironically, it is the law, even if you don't have your papers. And the where it can put you at an advantage is right now you're overstayed, you're facing risk of, some kind of enforcement. And if you are somehow, Lord forbid, but if you end up getting into trouble or end up in court, showing that you've complied with the law by filing your taxes can go a long way in immigration court, right? So you definitely want to make sure that you are looking at the possibility to get your ITIN and take it seriously, but you also want to be informed as well. So get in touch with us. We can talk to you and then we can help you to, decide based on the information we provide. Can you travel on a T visa to the Caribbean? No. And I would say the T visa, the main purpose of the T visa is to provide relief to people who are here who were in a very hard situation. The focus of the T visa is not necessarily to allow people to travel. You do have the ability to apply for a travel document, but in this climate, I would say wait till you get your permanent residence at least, because the focus of the T visa is that you're supposed to be here in the US. And, now traveling out of the US can present a certain level of complexity. So if my vow gets denied, can I remarry and apply AOS through my current partner? Uh, that could be a possibility. We have to understand your facts to be able to determine what would be best. That's where you definitely can talk to us or talk to your attorney about that possibility as well. Can you get citizenship with a misdemeanor? So now that's a very, very, very loaded question. Because what kind of misdemeanor? A misdemeanor can still have a serious effect on your good moral character, the good moral character findings of the officer, especially now that they've changed the rules. So, guys, they've changed the rules substantially for citizenship. And that means that you're going to have to, it's not just about filling out a form, an N400 form anymore. It really is, you're going to have to paint a picture through your documents and through your words about who you are. Now, there are two things that have changed. One is that now you have a misdemeanor, they can, even if it's minor, they are going to look in your area, and if they believe that the average citizen in your area doesn't get misdemeanors like yours, then they can deny you based on good moral character. So there, but that's not the end of the story. You can still redeem yourself by showing the positive factors outweigh the negative. So that means that they're going to look at things like, okay, you got the misdemeanor, what were the facts? You got the misdemeanor, but did you comply with the court? You got the misdemeanor, but are you rehabilitated? You got the misdemeanor, but what good have you done? Now, what positives have you done since then? So and they are taking that approach with all applications. So they're not just saying, oh, you don't have a criminal record, yay, you're approved. Now they're saying, now they're saying Tell us how have you gone above and beyond? We want to know more about you and how have you gone above and beyond to be a good person in the society, in your community, right? And so good person could mean that you're active in your neighborhood, that you are you take care of your family, that of course, taxes is always a part of it. But do you run a business? Have you been pursuing education? What constructive have you been doing? So you can. I say this. It can still be it's about adopting, guys, but it can still be so reachable to get there. But if it's done incorrectly, that's how this whole system is set up now. One misstep could then put you in denial instead of a straightforward approval. So get in touch with us. We can definitely help work through your citizenship and get you to the point where you can submit a successful application. And we have to understand whenever it comes to any offenses, but especially now, guys, they're not going to make it easy when it comes to they're not even making it easy if you have traffic tickets now. Here's the other change with citizenship that's making it harder is they can now go into your neighborhood and interview your neighbors. So they can go to your neighbors and ask your neighbors about you, and they can go to your job and ask your job about you. The way that you can prevent that from happening is by beating them to the punch and providing information like letters, reference or character letters from the get go. So, from your neighbors, from your work employer, you can show that you've been continuously employed from the get go. So, as you can see, you're putting a whole case together. This is not just about checking boxes on an N400. This is about, it's like putting together a resume. It's like putting together, that's how it is, like putting together a job packet to say, why do you deserve this job? It's similar in that you have to put your best foot forward and show your life, who you are, the life you've been living, and who you are in your community. And how is that a positive thing? How long does it take to receive a receipt after filing for removal of conditions? So right now everything is taking a while, but I would say maybe 2 weeks for that one. 2 weeks. But keep in mind and it depends also if it's a VAWA, meaning you're applying for a waiver, then you might still be within the 4 months, the 3 to 4 months that is taking. Does having a child outside of your marriage affect your application for citizenship? Great question. Yes, now it can, because infidelity. So if there was infidelity that broke up the marriage, then it can lead to denial of the application based on failure to show good moral character. So it can be an issue depending on the facts. Now, if you're already separated, but these are the things that now that you know that the risk factor here is very important to approach these things with caution in the application, or be ready to answer those questions. Can a stepmom citizen petition for a 9-year-old I-130 and then a biological mom file the adjustment? No. So the adjustment of status has to be connected. But why couldn't the stepmother do everything? So the stepmother, so this is where I say get a lawyer, right? Because that's very convoluted and you don't want to make any missteps, especially with a 9-year-old's papers. So you don't understand? No, guys, it's not the time. I know you're asking the question, which is great. But no, it's not the time to guess on things and like file papers, trial and error. They're not nice, right? So they're not there to look out for you. A lot of people mistake the USCIS thinking they're there to help. And I've seen so many times when people call the USCIS and the person who talks to them on the phone tells them, just, yeah, go do it. I think you can do it. And they say, oh, the person told me I could do it. And it's a completely wrong thing. And they end up in a lot of trouble. Right. So make sure that you're getting the help to do it right the first time. So you're not having to deal with getting a denial or getting some kind of ugly letter or notice to appear. Do I have to file taxes with my wife, kid? That's not mine for the green card. So I would say that's a tax question, especially if there's more complexity, as in, depending on who has the custody of the child, who gets to claim the child based on custody of the child. So that's a tax question. It, yeah. So filing, I would say there's less focus on the child being on your taxes, more so, are you filing jointly? When they're looking at your marriage, they're looking at, are you filing jointly? But the child is less of a focus. I think that's more of a tax question. If a citizen filed for a stepchild, live in the US, age 22, does she have to go back home to pick up paper? If a citizen filed for a stepchild, live in US, age 22, does she have to go back home to pick up paper? So it's going to depend. If the step parent filed for the person when they filed the I-130, they were under 21, then adjustment of status is still possible. So get legal representation. We can definitely help with that. But yeah, it may be doable, but we have to understand more facts. If the step parent filed the papers when they turned 22, that's gonna be a different story. But if they filed it when the petition when they were under 21, then that should be fine. How long does it take these days when you do a fiance visa? I would say plan for about a year and a half to 2 year process because it's consular processing. Do they skip marriage interview? No, they're not skipping the marriage interviews. They're scheduling those. Can a green card marry a visa holder and file for them? So I would say that at this now, if they overstay their visa, they're not going to qualify for adjustment of status. And that means that you can file the petition, but not the adjustment of status. But the adjustment of status is what gets them the green card while staying in the US, and they don't qualify for that. So I would say instead, if you file a petition for your spouse who overstayed and they're in the US, they're at a high risk for getting a notice to appear. That's the exact type of petition or situation they're looking for to issue notices to appear. So, getting citizenship may be the better option, but I'm not your attorney. I can't give specific legal advice here. So, you need to make sure you call us, talk to us about your options so we can advise specifically. Child outside marriage will affect the removal of conditions. They're going to have questions. So they are now looking, they're looking at everything. And if you have a child outside of the marriage, they'll definitely have questions. But it depends on your circumstances, right? Did you separate, but not divorce the person? And did you enter a relationship and end up having a baby then? If that's the case, then you could be explained. Get legal advice and representation. This is exactly what we help with. So call us and let's talk about your situation and then determine how to move forward. Okay. Any update on VAWA updates in terms of approvals during this unprecedented times? We've gotten 10-year green cards, VAWA work permits as usual for our clients this year. So no updates as in, nothing crazy. Processing times getting longer, but they are coming through. Please, is it safe to come seek asylum in the USA? No. So it depends on how you're doing it. If you feel unsafe, you can definitely give us a call and let's understand your situation so we can, give you some legal advice. Will a payment plan with IRS deny citizenship? No. It shows you are complying and you have a payment plan in place. My fiance has a 10-year multiple visa. Can we get married here and then just adjust his status, not as a fiance, as a spouse? If you're a US citizen and they are the spouse, they are your spouse, not your fiance, then that adjustment of status could be possible. Give us a call. This is not time to experiment and guess and play around with the paperwork. Having your fiance can face a lot of bad consequences if this goes wrong. So make sure you're doing it right from the get-go. Um, Good night. How, and we do represent clients in all 50 states and the globe. So no matter where you are, you're in Hawaii, you're in Puerto Rico, you're in Alaska, we can represent you. We represent clients all over the world. I've represented clients in Africa, in Asia. I've represented clients all over the world and all over the United States. So that tells you how efficient we are. We're doing the work all across the country. What happened TPS for Nepal? That it has ended. They're ending it. I've gotten a biometrics from my VAWA case, but no prima facie. Well, sometimes the biometric comes before the prima facie, and that's okay. Can a green card holder file for her mom and 5-year-old niece? No. So green card holders can't file for parents. How long are VAWA receipts taking? 3 to 4 months. Do you think Trump will extend TPS for Syria? I have serious doubts about that. They are ending it for most countries right now. So I have serious doubts that we're going to be seeing TPS coming through. Um, But what I would say here now, just because they've ended TPS doesn't mean that you can't look at other options. So if you qualified, you had TPS, you're looking now facing a potential end of TPS, then what you need to do is contact us and let's talk about other options. If you have TPS, what we want to look at is, obviously you're here because something was unstable in your country. And as an individual, do you still face certain threats if you go back to your country? Asylum could be your individual option here. And that depends on particular threats that you face. So, let's talk about other potential options. I got married recently. Since I got my green card, can I file for my Jamaican husband? Yes, a green card holders can apply for your spouse. So if your spouse, if he's outside of the United States and he qualifies in every way, absolutely get in touch with us. We do work on those spousal visas as well. Can you still file for adjustmental status with I-130? Yes, 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 you can. I know there's a lot of confusion about that, guys, but what I would say is the relief is still there, but where you need to be careful is procedurally doing it correctly, right? If you don't do it correctly, that's where the risk goes up. And in some cases, filing the petition by itself increases your risk. So get in touch with us. Let's talk about your case and let's file it. Let's file it, do it right. Why immigration still slow lately? Because of a lot of document or case changes. So both a lot of cases are being filed, but also they're doing a lot of changes on the back end and they're changing their procedures and processes. So they're slowing down. If I and they're fired a ton of people too. So in Colorado for 6 months. Will that affect my case? I'm not sure. I would have to understand your full case. I'm removing conditions on my green card and I'm living in Michigan, but I'm getting a winter job. So, life happens. We have to get jobs away from our spouses sometimes. And you just have to document everything. So, we can definitely help work with you on that. That's why we're here to help. Yes, no moving and then not understanding how to provide the right evidence to cover your basis is where it can affect your case. So you want to make sure that you get the help. If you get a job outside of the state from your spouse, then what kind of other evidence can you show that your marriage continues? Phone records, travel records showing you moving back and forth, showing you're still paying bills for the house. Are you in New York, Brooklyn? We don't have an office in New York. But as immigration attorneys, we have a federal practice. That means we practice all over the United States, in all 50 states and the globe. We have many clients who are in New York. So give us a call. We can help you. I-130 was scheduled for interview, but no work permit as yet. Is that okay? Um, is it okay? I'm not sure. It just depends on what the facts are in your case. It may be, but do you have a pending I-485 along with the I-130? Is it okay to say no to bear arms questions on N-400? So um, that's definitely going to, because those questions are there to, um, they want to make sure that you're fully willing to do what it takes as a US citizen. Not answering that question can definitely delay your case and potentially result in a denial, just depending on your reason for not bearing arms. So it depends, but is there a religious basis? But it's definitely going to complicate your case, especially now that they're in all applications across the board. They are now, you know, talking about looking for anti-Americanism, and they are so anti-Americanism is one. So they're gonna definitely insinuate something like that, right? That there's some kind of anti-Americanism, because it's that subjective. It's very vague and it's that subjective. So um, can your removal of conditions get denied, and why so? Yes, absolutely can be denied if you don't put your best foot forward and submit a good, solid, strong application. So and now nothing is stopping them from doing that, right? They've just sent it to court. Can you reapply for EB1 after EB2 was not approved? Yeah, because it's a different category, but does it make sense to apply for EB1? Because the standard for EB1 is much higher than the EB2. EB1, if you're going for extraordinary ability. How long does it take USIS to approve work permit and in Texas for marriage case? So the latest one that we got is 2 months. I say 3 to 6 months for work permit for marriage base. Should I worry that I didn't receive a prima facie? It depends on how long you've been waiting. After your removal of conditions get denied, can they deport you? They'll put you in removal proceedings and you'll have a second chance to go before a judge, which you don't want it to get to that point. That's where investing in the first process, make sure you're doing it right, make sure you do your best, you submit the best application from the forefront. You want to do that, because once it goes before the judge, the judge is going to say yay or nay. If it's nay, then you're getting deported. So you have a last chance to present to the judge why you should still have your conditions removed to get the 10-year. If 9-year I-130 not approved from 2024, should I do adjustment now or best to wait on approval? Get in touch with us, Samantha. That's the best thing, because procedurally it's going to be so important. But we need to understand who is filing the I-130, right? Your 9-year-old is being petitioned. Who filed the I-130? And then, because filing an I-130 alone is not going to protect the child, right? If there are situations where you can file an adjustment of status right now, but do they qualify for that? If it's a green card holder that filed the I-130, They need to wait for their priority date to become current. These are all the things we do, right? So I say this, you should not sit down and stress about things that you are too complicated. Now is not the time to sit down and try to figure out laws that you have no idea about, right? It's not the time, because one misstep is can lead to a very expensive consequences, personally and professionally, financially. So get in touch with us. Let's talk, figure out the facts, and then move forward with the best course of action. Can judge or talk to your attorney if you're already represented. Can judge your case on first hearing. No. So on the first hearing is usually a master calendar hearing where they review the NTA, notice to appear, and then they ask you whether you admit or deny the charges in the NTA and what your defenses are. Sometimes they put a pleading schedule in, to submit pleadings and motions, and then they set the next date for the individual hearing. Can you travel on advance parole at this time? Yeah, it's there for travel, but why? Um, what's your risk right now? Is it worth the risk? Thank you so much for the gifts and the love. I appreciate it. I started removing conditions from February. How much longer does reconditions usually take? Could take up to 4 years. All right. I am I'm going to head out. I'm just gonna check quickly any more questions. My little sister is 11. Both parents died. She have a visa. How do I get her to stay here in America? So there are different ways. If she's outside of the United States, you may have to look at the option of adoption. If she's in the United States, then there's a process called SIJS that might be an option. So give us a call, talk to us, and then we can determine what would be the best course of action. Should I worry if marriage-based interview is being reviewed? Um, it depends on what came up at the interview. If really didn't feel like a good interview, sometimes it's not been a good interview, then at that point, yeah, but I don't know what happened in the interview. So I wouldn't be able to. Sometimes the officer will say, okay, I'm going to do a little review before I send the answer, and that's normal. Usually a week or two, you still get the decision. Been waiting for I-130 approval over 3 years. That's not out of the ordinary. Can I adjust my depending on your category, can I adjust my status if my husband is a permanent resident? If your priority date is current, so if your priority date is current, you have not overstayed your visa, and your spouse is a permanent resident, then yes. If you don't have no idea what I just referred to, it's time to give us a call and talk to us about your individual case, and then we can advise on the best course of action going forward. But you need the conditions need to be right, in order to apply. Um, Let me see any more on Instagram. Good night. If my 9-year-old stepmom, my 9-year stepmom who is citizen, file I-130 for him. So stepmom files I-130 for 9-year-old, I think, from September, and still no approval. Since she didn't file the adjustment of status, can I, the green card holder, petition? No. So that I-130 has to be connected to the adjustment of status for it to work. Why isn't the US citizen filing the adjustment of status? Let's talk about that, because VAWA may be an option if your 9-year-old was starting to be mistreated by the stepmom, for example. So if there's some kind of tension like that, I want to talk to you to figure out what the facts are so we can jump on it quickly, because an adjustment of status should have been filed with an I-130 to complete it. Your 9-year old is not going to get their green card without that adjustment of status, and that should have been filed with the I-130. So this is an example where you don't if you don't know the procedural steps, you hire an attorney, to get it right the first time, because there's a lot of delay here because of that misstep. We got questions on YouTube. Okay, I'll get to those. Did my interview on August 5th. Okay, August 5th. So, yeah, a few weeks. And I don't know what happened at the interview, though. So, they may just want to look things over for a little before they decide. Overstayed. So, I see overstayed. So, if you overstayed and you're looking to apply for a benefit, it's time to call us. Can we get advance parole based on U or T? What is the processing time for it? Yes, you can get advance parole. Is it a great time to apply for advance parole with a U or T? I would say no. It's not really a good time to apply to travel outside of the United States on a U or a T. I think focus on getting your green card first. Right now, green card holders are being detained. So, you know, imagine having a travel document, which is just like a measly permission to say, sure, you can leave the country, but keep in mind, you come back, we don't guarantee we're going to let you back in, right? So you have to understand your risk before you can apply for advance parole, but is it worth the risk right now? Can I still file for VAWA if my marriage petition was denied for almost 3 years and my spouse is not ready to help? Uh, so let's talk. Keep in mind previous denials, they are going to look at those previous denials, but we want to understand your situation. It's a possibility that that could go forward. Give us a call. Is there a chance of an I-290B approval? Yes, absolutely, there is. So I have seen approvals at the I-290B stage, and it's definitely worth it. And that's another thing, guys. When you have, if you have a benefit pending and you do get denied for some reason, at least you still have the ability to pursue appeals in some cases, and you can still get second chances to refile if new evidence comes up. But that also provides you, having started a benefit, that applying for something that you qualify for, you are able to continue to pursue that. Even if you don't get it the first time, you can appeal it, right? And that while that appeal is going forward, you still have the ability to be here while your process is going forward. Biometrics is done for T visa. When can I expect BFD and EAD? What are the processing times? So I would say right now it's 4 months to get the receipt notice, about 2 months later, biometrics. Then about 3 months later is BFD, and then 4 months later it's work permit. This past week, though, we did get the work permit and the BFD at the same time, which is a good sign. So hopefully we see more of that. All right. Let's see. Any more questions? Any more questions? These are all great questions. I just want to stay here all night and answer questions. How long for a T visa to be approved? So I would say little less than 2 years right now. I-130 doesn't protect from deportation, but what if you're still in process and pending, but have a removal? So this is the deal here. It may help at the removal stage. So if you have a pending process, I-130 it may help in the court stage where you may be able to pursue adjustment of status before a judge, for example. So this is where I say, though, you need to understand the pros and the cons of filing these. Because with the I-130 alone, if you're not in removal, you have an I-130 processing, you're thinking about filing an I-130. Know that if you file that I-130 and you don't have an adjustment of status application at the same time, it could trigger a notice to appear. So where you didn't have any court, now you may have court, right? So it's about determining whether it's worth the risk. What are the pros and the cons? I have a pending VAWA case. However, I was recently diagnosed with cancer. I'm so sorry. No work permit or social just yet. So no insurance. Is it possible to submit a request? Absolutely. This is the exact type of situation you would submit an expedite. Absolutely. So submit proof of the diagnosis and make sure you're stating the urgency of it to move forward. And my prayers, I'm going to have my prayers up for you to get well soon. I applied for adjustment of status as F1 student by marriage to a US citizen. The I-130 approved, EAD approved, but I-485 pending. We have done the interview before the I-130 was approved. So in that case, are they waiting for something for the I-485? That would be my question. Did you hand in everything? They may be looking it over again. So it just depends. Okay, my I-485 is still pending after I-130 has been approved for almost a month. What to do next? So that's not out of the ordinary. They might be doing some extra checks. I would say overcoming the I-130 is a big deal, right? Because that's usually in the process here in the US when you're doing marriage based. The I-130 is the big deal. You've gotten that approved? I say no. Is there anything in your background you're concerned about? Anything like any past offenses, any past immigration violations? I would be concerned then. If you have nothing like that, no concerns about complications, then it might just be they're doing a review, they're doing extra background checks before they approve the I-485. Okay, so you haven't received the receipt notice. So do you wait until, so usually in this case, what we would do, so if you haven't received the receipt notice, what we do is we would contact them using the hotline. So we have an attorney hotline, we'd contact them and just state name. We may not have all the information, but let them know that we're requesting an expedite and we haven't received the receipt notice. In that case, what sometimes happens is we get the receipt notice and then everything starts to move a little faster if it's approved. And sometimes they don't even say expedite approved. You just start to see things moving. All right, that's going to be it from me. Thank you so much for all these great questions and your time tonight. Okay, I see another question. I can't resist, so I'm going to answer and then I have to head out. I recently got married. My wife, a US citizen, and I live in different states for grad school, but visit monthly. We plan 3 months. We plan three moving together. I guess we plan to move in together after graduation next May. Should we go ahead and file now? Let's talk. Talk to us because I would say if you are here on a student visa, you have time to build your case. Then it may not be as urgent, right? But what are your goals? We need to talk to you. What are your goals I want to understand, when does your visa expire? You know, I need to understand all of that to decide whether, how urgent, how should you be treating the timeline, to plan out your timeline. So give us a call, talk to us. Now, the way you are going to do that, you can go to the link in the profile, go to the link in the description of the video, and you'll be able to see the link tree. Click on the link if you want to schedule your own appointment online. We have an initial evaluation form. You go through that brief form, and then you can schedule your own appointment and get on the calendar ASAP. And or you can call the office. We are working 24 hours a day. So you can call the office, talk to them. They will help get you through it. And they do a brief initial evaluation just to make sure that what you're calling about, we can help you with. So that helps us to not waste your time and money. We want to at least have a hint that you do qualify for something we can help you with. So they'll walk you through that initial evaluation. The form also does the same thing. It's not a replacement for legal advice, but it helps us to determine whether there is something that we don't waste your time. Give us a call, talk to us, or schedule your own appointment. Our schedules are filling up very quickly, and I want to help you. We are needed more than ever, and this is my mission. Right now, I want to make sure that people get through this process as smoothly as possible without the unnecessary complications, right? So make sure you're doing it right from the get go. Get in touch. Let's talk and get this right the first time and get you to your goals of getting your residence, getting work permit, getting protection here in the US. I see a ton of questions. I'm going to have to head off, but save your questions, like, share, subscribe, follow, and then join me. You'll see when I come on live tomorrow. Join me and ask your questions tomorrow. All right. Or give us a call and talk to us in an appointment. Have a good one, guys. Have a good night. Bye bye.